Let me welcome you to this side event to the working group discussions about the Oxford process on international law protections in cyberspace. My name is Harold Coe. I'm Sterling Professor of International Law at Yale Law School, former legal advisor and Assistant Secretary for Human Rights at the State Department. It's been my honor to be involved with the Oxford process from the beginning. It's very fortunate that we're here at the Japan Society because one of our hosts is the government of Japan, and we'll be hearing from one of its representatives momentarily. We're in the shadow of the Microsoft office at 1 Dag Hammarskjöld Plaza, another one of our sponsors. We're in the shadow of the United Nations, in which this important discussion is going on this week. And we are joined by count 5 researchers from the Oxford Institute for Ethics Law and Armed Conflict, ELAC, who have all been working together. So this has been a genuinely multi-stakeholder initiative. Some events are so important that it takes not one but 2 Undersecretary Generals to introduce the project, and we are very blessed today to have the 2 of them. And so let me introduce them in the order in which they will speak. The first is the Undersecretary General and High Representative for Disarmament Affairs, Madam Izumi Nakamitsu. She has been a professor at Hitotsubashi University. She's an expert on peacekeeping, refugees, crisis response, and democracy and electoral assistance at IIDEA. And she's been the High Representative for Disarmament Affairs since 2017. Yesterday, she opened this important meeting at the UN by calling comprised of concrete norms of responsible state behavior and international law underpinned by capacity building to ensure cooperation, information exchange, to prevent escalation of harm, and to uphold human rights. There could be no better introduction for what we are trying to accomplish today than to hear from Undersecretary General Nakamitsu. So let me pass you the microphone.
Thank you very much. I thought my colleague and friend Miguel was going first, but I am very, very pleased to be here. It's almost home, Japan Society. But before I just say a few words, let me thank you so very much for organizing this. Of course, first and foremost to the Oxford Institute for Ethics, Law and Armed Conflict, and of course, good friends, Microsoft, and I can't see my colleague from the Japanese mission, but also with the support of Permanent Mission of Japan. It's really great to see a lot of friends and colleagues and, if you will, comrades working together on this very important issue. And as you all know, it is really an important week for all of us, seized of the international peace and security challenges relating to cyberspace. Member states are embarking on a new 5-year mandate in the Openended working group, which just started yesterday. And this focuses on the security of and in the use of information and communication technologies, or ICT for short. This is the UN terminology that we have been using. Just to recap, the mandate of this new Open-Ended working group has 3 primary substantive components. The first is a priority, of course. It is to further develop the rules, norms, and principles of responsible behavior of states. And this is very key. And this, discussions focused on behavior of states is really a focus of attention started in cyberspace, but also now expanding to various other new domains. And I think it is very important that we really think about what constitutes responsible behavior, what constitutes irresponsible, and what might be threatening behavior. So it's an interesting process that you are embarking on. The second, it is to consider initiatives of states aimed at ensuring security in the use of ICTs. Obviously, you have all been discussing this actually for 2 decades almost. And then the third, obviously it is very important to study and seek common understanding on existing and potential threats in the sphere of information security, including data security and possible cooperative measures to prevent and counter such threats. It is also tasked to study and seek common understanding on how international law applies to the use of ICTs by states, and we're going to hear all about that from Miguel. Gaining a greater clarity on how international law applies to the use of ICTs by states really remains a critically important objective, and it is also one of the contentious or controversial aspects of the efforts that we have been doing. As more actors, of course, incorporate cyber means and methods into their security strategies, the lack of common understanding on how the law applies can result in cyber incidents, leading to instability and, of course, potentially unintended escalation. And particular concern, I would say, has been expressed in relation to acts that cause physical harm, analogous to attacks undertaken with conventional weapons, other types of conventional weapons, or acts that might result in the incidental loss of civilian life, injury to civilians, or damage to civilian objects. And from this perspective, I'm pleased to say that this new intergovernmental process, OEWG, is not starting from scratch. And I think you will all agree on that. Member states with really important essential inputs from a variety of stakeholders, including academia, civil society, and of course industry, have worked over the last 2 decades, thanks to Michelle, one of the initiators of that process, to build common understanding and develop normative framework. And so we have come a long way in that. Important progress has been made on the application of international law to the use of ICTs. For example, of course, there is no longer, I would say, any doubts that international law, and in particular the Charter of the United Nations, is applicable and essential to maintaining peace and stability, and for promoting an open, secure, stable, accessible, and peaceful ICT environment. There is no longer any doubts about that. The most recent report of the GGE, the group of governmental experts, added, I would say, very important layer of understanding to how international law applies, including in relation to various provisions of the UN Charter, such as peaceful resolution of disputes, non-interference in the internal affairs of states, and non-use of force in international affairs. If you actually take a look at it, there are almost, I think, 11 pages of quite detailed guidance in those aspects. So it's been quite impressive progress that you have all been making. I would just single out, maybe point out 2 key aspects, however. More work definitely is needed on other critical aspects, of course, including in relation to the right of defense, very controversial, as well as on how and when the principles of international humanitarian law apply to the use of ICTs by states. Most recent group of GGE importantly recognized the need for further study on how and when principles of international humanitarian law apply. This was the first time that they explicitly mentioned this, so it was very important breakthrough, I would say. And underscore that recalling these principles by no means legitimizes or encourages conflict. So that was, as I said, in our view, a very important development that was achieved recently. Now, as the new open-ended working group moves forward, The inputs from a variety of experts, from legal experts to computer scientists to representatives of private sector, will only become really more valuable. So I hope that the states will be able to sort out these stakeholder issues as we speak. It's an important aspect of open-ended working group process. The 5 statements developed by Oxford process. By the way, I think this Oxford process really has been adding really important substantive work, and especially those 5 statements developed by the Oxford process demonstrate the importance of leveraging broad and diverse expertise from different disciplines. You've taken really interdisciplinary approach, if you will, and this approach really provides for a comprehensive understanding of the types of harm engendered by the malicious ICT activities, the kinds of activities that we see now almost on a daily basis, as well as measures to prevent or mitigate or redress associated harm. So I went through some of those things before I came here, and I thought it was very, very interesting. I learned a lot also by studying some of the work that you have done. The process also takes a highly contextual approach, which is also another important aspect, because it allows for the statements to tackle the most pressing legal questions of the moment, including the regulation of ransomware operations and safeguarding, for example, vaccine research, an aspect that has been really highlighted by the Secretary General during the COVID pandemic. So, distinguished participants, dear friends, clarifying application of international law to the use of ICTs by states remains a really high priority, and I would say comes with urgency as well. So initiatives such as this one will really add value to the work that people are doing in the conference room. So please continue doing that, and thank you very much. I'm really keen to listen to the exchanges and looking forward to continuing to work with you. Again, thank you very much for all the efforts, and great to be here amongst friends. Thank you.
Thank you, Undersecretary Nakamitsu. You have done a wonderful job clarifying the policy stakes of the discussions that are going on this week, and the value of this side event to that. You can think of us at a state we could call applicability of international law 2.0. In the early going, there was a lot of debate about whether international law applies in cyberspace. There have been international statements and national statements, but now we are well into phase 2.0, which is how it applies, what are the prohibited methods of cyber activity, what are the protected objects of cyber activity. And it was in the middle of the pandemic that this became the focus of discussion for a group of international lawyers. International lawyers are notoriously prone to disagreement. Usually 5 of them cannot agree where to have lunch. But here, each of these 5 statements has been joined by over 100 international lawyers. And I'm very proud and honored that one of the people who has participated and been one of the strongest supporters from the beginning, in fact, participating actively in all of the sessions, has been my friend and colleague, Undersecretary General Miguel de Serpa Suarez, who is the Undersecretary for Legal Affairs and head of the Office of Legal Affairs at the United Nations. He is quite literally the international lawyer for the world. He preceded this term of duty, which began 8 years ago, actually at the beginning of the cyber discussion, by service as the legal advisor at the Foreign Ministry in Lisbon, where he was very much respected by all of his national colleagues. And before that, as the legal advisor to the permanent representative of Portugal to the European Union in Brussels. And so we welcome him here today to give the legal point of view on this set of issues. Miguel.
Thank you. Thank you, Harold. And I had the privilege of being involved in the Oxford process, and you are responsible for that. I thank you there. And, special greeting to all our colleagues, Duncan Hollis, Svetlina, and Dapo, who is following us, I hope. So the world today is radically different from the one in which the Charter of the United Nations was drafted more than 75 years ago. Today, we are, of course, more connected, interdependent than we ever were. The information and communication technologies that we now take for granted has been a revolution in the way we communicate, the way we work, etc. And with the ongoing COVID-19 pandemic, our dependency on information and communication technologies has accelerated. It has allowed us to continue working to minimize the spread of COVID-19, and it has allowed us to develop new methods of work. It continues to enable us to harness different ideas, increase productivity, improving lives throughout the world. I wanted to come back to some of the thinking of the Secretary General in this field, and if you recall in his report, Our Common Agenda, he described the internet as, and I quote, a global public good that should benefit everyone, everywhere. But at the same time, the potential harms of the digital domain risk overshadowing its benefits. So the Secretary General points to serious and urgent ethical, social, and regulatory questions which confront us, including with respect to the lack of accountability in cyberspace. And because of that, it concludes it is time to protect the online space and strengthen its governance. Now, urgent action is needed. Increased reliance on information and communication technologies has exacerbated vulnerabilities, creating opportunities for malicious exploitation. For example, during the pandemic, the internet has enabled the best minds from all over the world to collaborate and confront the spread of the virus. But at the same time, systems relied upon by hospitals, labs, and medical facilities in recent times became targets of cyber operations. So there is a need to address the unique challenges presented by sophisticated and continually evolving technologies. And in my view, a meaningful role should be given to international law in this context. So there is no longer any doubt that international law, and in particular the United Nations Charter, is applicable and essential to maintaining peace and stability and for promoting an open, secure, stable, accessible, and peaceful ICT environment. However, from an international law perspective, there remains to be open questions, and in particular cybersecurity incidents such as the one I raised, and those raise also important legal questions. And these include questions on the applicability of state responsibility, given the actors involved, state sovereignty in the context of technology infrastructure, measures a state may take under international law as cyber defense measures, just to name a few. I note that there are ongoing discussions on these issues, including in the substantive session of the new Open-Ended Working Group on security of and in the use of information and communication technologies, which started yesterday, as Izumi was describing. I mean, I finished my 6th committee. You're going to have the your busy week. Now, I know that it has a broad mandate relating to the different aspects of the use of ICTs, including to look into the specific question of how international law applies to the use of information and communication technologies by states. International law, of course, does not operate in a vacuum. I'm also very interested in how the discussions will lead to the further development of the rules, norms, and principles of responsible behavior of states. It may be tempting to characterize the absence so far of a binding international legal instrument in relation to cybersecurity as a failure of international cooperation. I disagree. The active participation in various international fora, such as at the United Nations, including at the Open-Ended Working Group, as well as in the group of governmental experts on advancing responsible state behavior in cyberspace in the context of international security, has resulted in the articulation of the rules, norms, and principles which now guide states' actions. The General Assembly, as recently as of 6 December, not only reaffirmed that the voluntary and non-binding norms of responsible state behavior can reduce risk to international peace and security and stability, but it also noted the possibility of future elaboration of additional binding obligations. All of us here today can play an important role in the evolution of international law in this unique area. The Secretary General has emphasized the need for a form of multilateralism that is more networked, more inclusive, and more effective in addressing 21st century challenges. A global dialogue is imperative to address contemporary legal issues in the context of cybersecurity. A global dialogue between various stakeholders, including states, academics, and industry experts, can enrich the discussion to generate creative solutions. So I thank very much the organizers for continuing to hold these discussions through the Oxford process on international law protections in cyberspace. Its unique contextual approach, which examines the law as it applies to specific objects of protection, bringing together interdisciplinary focus, can certainly add value to the discourse. I look forward to the discussions today. Thank you very much for your patience.
Thank you to our two honored guests and Undersecretary Generals for this wonderful and thoughtful opening. Among the themes that have been raised here, most recently by Miguel, is that in the face of networked threats, we need networked multilateralism supported by multi-stakeholder initiatives that provide a resource for capacity building at all levels. And from the Undersecretary General Nakamitsu, we learned about how the various bodies of international law, not just the laws of the UN Charter, but the rules of use of force, international humanitarian law, and human rights law, all come together to create a kind of patchwork or quilt of legal rules that could lead us to rules, norms, and principles of responsible state behavior. In the hour that we have left, we want to divide it into three parts. The third part, which I flagged for you now, is question and answer, both from those in the room and those who are online. Those can be delivered by the chat and passed to me, and we can discuss them in the third part of the presentation. But what we wanted to do in the next two phases of this discussion is to give more a sense of what the Oxford process is, how it has evolved, and how it interfaces with the Open-Ended Working Group process in which many of you are delegates. So moving first to a virtual discussion about the history, goals, and methodology of the Oxford process, we have online from Oxford, Professor Dapo Akande, our colleague, one of the conveners of this process, professor in public international law at the Blavatnik School of Government, and most recently elected as the United Kingdom's expert on the International Law Commission. We also have with him Dr. Talita D'Souza Diaz, who is a research fellow at Oxford at Jesus College and also a leading researcher at the Ethics, Law, and Armed Conflict Institute, who has been playing a driving role, particularly on issues of due diligence, and our good friend Tomohiro Mikanagi, the Deputy Director General of the International Legal Affairs Bureau at the Ministry of Foreign Affairs in Japan, who joins us from Japan. So they will give us a sense of the overview, and then we will do a deeper dive with other colleagues who are here about the 5 particular statements that have been issued, exactly what they say and how they're relevant to the evolution of norms that have been developed through this process. So let me start at the most basic level with Professor Dapo Akande. As a founder of this process, which began during the pandemic, what exactly is this process seeking to achieve? And what exactly is the value or legal precedent of a set of statements signed by so many international law professors and scholars on so many different subjects? What's the vision, Dapo, and how do you see it as having evolved over the now 1.5, 2 years that this process has been going on?
Thank you very much, Harold. Let me also extend my own welcome who is attending, those in the room. Special thanks, of course, to the 2 Undersecretary Generals who have provided really valuable opening remarks for this event. So just to come to Harold's question about what the value of the process is, in fact, as has been explained by the 2 Undersecretary Generals, we have a lot of agreement that international law applies to the operations of states in cyberspace, and that international law applies also in relation to how states generally ought to behave in responding to malicious cyber behavior. What we don't have, and what we've been trying to achieve, both through the Open-Ended Working Group and through the GGE process, is some elaboration of what it is actually that international law provides. So what are the rules of international law that apply in this space? And this is exactly what the Oxford process is trying to provide some consensus on. So the first thing that I would say is that what we're trying to do is to, if you like, model the sorts of rules that international law actually does provide for. So there's agreement that international law applies, but what we're trying to do is to give flesh to that, to those statements that international law applies. So it's bringing together a diverse group of stakeholders. It's academics, it's government officials, it's people from industry, it's former judges from international tribunals, to try to show that actually there's a lot more consensus about what international law says than is sometimes thought to be the case. So through these workshops where we bring people together and through the statements that result from these workshops, we see, and we can see it in the text, in the black and white text that is generated, we see that actually a wide range of people actually agree on what international law says. And I think that should give us, as when I say give us, I mean the international community as a whole, actually a lot more confidence as to the fact that existing rules of international law apply, and we don't necessarily actually need to develop new rules. We just need to clarify actually what those existing rules are. So that's the vision, Harold.
So this is a very striking contrast. In a governmental process where you have consensus decision-making, often a single or a few outliers can break or disrupt a consensus. But in a consensus process with regard to the explication of norms, it may turn out that there is an extremely high degree of agreement among international lawyers of many different nationalities and viewpoints that certain kinds of actions are illegal per se or apply illegal methods and therefore are forbidden by international law as it currently exists. Now, that's easy to do and to say if you are a private stakeholder or an academic. Let me turn to Tomo Mikanagi. The government of Japan has been active in the Oxford process from the very beginning. You've been very active in the process of norm declaration and codification. You yourself, Tomo, in your time at the embassy in London, working with both Oxford and Cambridge universities, have been a pioneer in focusing on state responsibility in this area. Why is the Oxford process for you an important initiative for states? Why can't this just be left to publicists? Oh, Tomo, I think you're on mute.
Harold, can you hear me now?
Yes.
Thank you. Thank you, Harold, for good, kind introduction. It's a great honor for me to participate in this side event. And the Japanese government is very honored to support this Oxford process from the beginning. Why Oxford process is important for the states? I think Oxford process is very unique in its broad participants, both from academia and practitioners. And it is clearly focusing on the ongoing challenges such as cyber attacks to the healthcare sectors during the COVID-19 pandemic, and provide concrete context to discuss what kind of laws applies to these situations. And the statements issued by after the discussion, of course, important, but for me, the briefing and discussion preceding these statements are also very useful. Issues involved tend to be rather technical for lawyers like me, and briefing by technical experts provided useful and necessary background information for the discussion. And that is, I think, why it attracted government officials as well, indirectly involved in the OEWG and GGE process, like me, who are looking for the opportunities for informal discussion rather than formal, statement style discussion, and it proved particularly effective. Because of the COVID-19, international travel was restricted, and it served as a kind of retreat-style meeting for officials, academia, and practitioners to discuss these important things. Thank you.
Thank you, Tomo. So Tomo has highlighted the fact that the entire Oxford process has been itself a cyber process. And it began during the early days of the pandemic. And the 5 statements that have played out have all been because the participants by consensus decided that whatever disagreements may exist, we can all agree that some things are illegal. For example, use of cyber tools to attack the healthcare sector, to interfere with vaccine research at a time when we were all looking for vaccines, to interfere with elections at the moment when people are ready to go and vote, to engage in certain kinds of deceptive or harmful information operations, and then finally the use of ransomware. My question for you, Dr. D'Souza Diaz Talita, is across these 5 statements, though, there has been a continuous principle, namely the idea of due diligence. And this is something that you and your colleague, Dr. Antonio Coco of Essex University, who's also online, have been very focused upon. Can you tell us, what does it mean for a state to exercise due diligence in this area? How do we know when the state has fulfilled its responsibilities, and why does it matter?
So thank you so much, Harold. Indeed, we have been quite active on due diligence matters. And in response to your first question, or to your first point about how due diligence is reflected in the statement, so each and every statement that we have produced so far has a dedicated paragraph or two on due diligence. And if you look at the texts of each statement, you can see the evolution of how due diligence has been framed from a more general statement about what due diligence is about, very generally what it entails, to specific guidance on what states must do to fulfill with their various due diligence obligations. And it's worth reiterating that due diligence is not just one specific rule or principle. It may be more than one rule, and that's what we found in our studies here in Oxford, that there's more than one due diligence obligation that applies in the cyber context. So what does it mean for a state to exercise due diligence? So it means many things, and that's actually an advantage of due diligence and an importance of due diligence as well. It's this flexibility that it gives to states. So I can give a few examples. So one example could be, for example, adopting legislation to prevent cybercrime, to prevent malicious cyber attacks, to institute investigatory proceedings, to try cases of malicious cyber operations, but also to exercise cybersecurity, basic cybersecurity measures, to exercise international cooperation, and also to engage in capacity building and also institutional arrangements. But the bottom line is that due diligence is about prevention. It's about ensuring that bad things don't happen in the cyber domain. So, and that's another advantage, and that's another value of focusing on due diligence, because it's forward looking. So we are avoiding big issues before they actually happen. And so this is one of the big values. And we do this in a non-confrontational way with due diligence, because we are not necessarily focusing on the state from where a certain operation emanates. But we are focusing, we're not focusing on the responsible actor, who's behind a certain operation. We're focusing on measures of prevention, what states can do better to ensure that these types of operations don't reoccur. So that's what due diligence is about in a nutshell. You can find due diligence in paragraphs 4 and 5 of each of those 5 statements. And this is a really important obligation that we must be looking at. Thank you.
And Talita, how do we know when a state has not exercised due diligence? And if so, what should their liability be?
So when do we know? So when a state having the capacity to act and having knowledge of a certain type of operation that causes adverse effects on another state, or infringes upon the rights of another state, causes transboundary harm, and a state fails to prevent that operation, or a state fails to mitigate the effects of that operation, or fails to redress that malicious operation, that is a breach of due diligence. So, for example, not just engaging itself on these malicious cyber operations, but also enabling non-state actors to perform these operations in a state's territory, also failing to communicate to the victim state that there has been a malicious cyber operation in a state's territory. So this would be a breach of a due diligence obligation. In terms of liability, liability might arise if the harm occurs later on in time, and that engages a state's traditional responsibility under the Articles on State Responsibility. And also it might engage liability for failing to redress harm. If the harm arises and a state fails to pay compensation or to remedy the harm in another way. So there are these two types of liability or responsibility at play.
And so when you're using the word transboundary harm, you're essentially translating to cyber from other substantive contexts like international environmental law or the like. Is that right? You're saying this is not a novel concept. It's just being applied as a matter of existing law in this cyber area.
Absolutely. And this concept of transboundary harm is not itself limited to the environmental context. It became prominent and the environmental context because of the work of the ILC on this topic. But actually, it's a broader principle, which we call the no harm principle. And the ILC itself acknowledged that it applied to transboundary harms, not only to the ecological environment, but also transboundary harms to persons and property. And there's evidence in state practice and opinion areas that it also applies to non-physical spaces. And that includes information and communications technology. So that's one of the conclusions that we've arrived in our study on due diligence. And this is reflected in the statements as well, the no harm principle.
So this is a perfect lead into you, Dapo. Why do we need these Oxford process principles? After all, we have the OEWG, we have the GGE, we have the Paris Call, we have other initiatives. Why do we need an Oxford process at this point? Is it competitive? Does it dilute the energy of these processes? What did the conveners of the Oxford process see as the value of doing things the way that you've chosen to do them?
Thanks, Harold. So no, it's definitely not a competitive endeavor. You know, the Oxford process and the participants in the Oxford process are different from the participants in the OEWG and the GGE. I suppose the first thing to note is that, of course, states have a really crucial role to play in elaborating on and acknowledging the rules of international law. But of course, other actors have a role to play as well in clarifying what international law is in this area. So the first thing that I would say is that what we've been seeking to do is actually to go in the first instance to look at particular, as we've described them, objects of protection. So what we've been saying is these are particular areas where international law provides protection to particular types of objects, and we've been trying to clarify that. We're not suggesting that necessarily the OEWG or the GGE ought to take exactly that same approach, but this is a need in response to actual events that have happened in the world. So to provide clarity on those objects of protection. Secondly, we've been looking at certain methods of operation in cyberspace. So certain sort of techniques or certain types of activities. So in that context, we've looked at ransomware attacks. We have looked at what we called information operations, disinformation, misinformation. And again, this is not to say that in the OEWG that states have to take exactly this approach. But what we've been trying to do is to say that actually when you look at these methods of operation, consensus can be reached on certain things that are unlawful for states to do. And also consensus can be reached actually on certain obligations that states have, the conversation you've just been having with Telita on due diligence, positive obligations that states have in that regard. So the reason that I have spoken about this focus on methods of protection, on objects of protection and methods, is that this is very different actually from an approach that just looks at the rules in the abstract. And there are many enterprises that looks at the rules in the abstract, and they're very valuable, where you say, okay, let's look at what are the international law rules relating to the use of force? What are the international law rules relating to non-intervention? What are the international law rules in relation to IHL? What are the international law rules in relation to due diligence, et cetera, all very valuable. What we've been trying to do is to say, really, how do these rules apply? How do they apply to the particular problems that we're actually facing in the world? How do they apply when we're dealing with attacks that we see on healthcare? How do they apply with attacks on electoral systems? And how do they apply with respect to particular types of operations? That's what we focused on. It's really on the application of the rules rather than thinking about the rules in the abstract.
And Dapo, as someone who is about to become a member of the International Law Commission, how would you compare and contrast the Oxford process to the kind of progressive development of international law that the International Law Commission does?
So I suppose, I mean, the first thing that I'd say is, of course, the International Law Commission has a specific mandate given to it by the UN and given to it by the General Assembly. You know, it's got a mandate that comes from states to engage in the codification and the progressive development of international law. So in that sense, it has a role that's unique. It's given that mandate by states. Those of us in the Oxford process were very grateful for the participation of states and other stakeholders. We don't, of course, claim to have been given that mandate by states, but we're appreciative of the participation of states. So that's a contrast. However, I suppose what I would suggest is similar, is that one of the strengths of a body like the International Law Commission is that you have experts from all across the world who are deliberating on what international law says about a particular issue or topic or problem, and then reaching consensus on what international law says. And that's why it's really valuable, the work of the ILC. It's the mandate that comes from states, it's the process that they adopt, but it's also the fact that when you have international lawyers from all across the world reaching consensus on what international law says, that's powerful. It's different from, you know, those of us who are academics writing our own private works on international law. Now, in that sense, the Oxford process mirrors this enterprise. What we're trying to do and what we've, I think, been successful in doing is gathering international lawyers from all across the world to come together to discuss the issue and then to be able to agree through a deliberative process on what the rules of international law are. So it's not just a case of one or two or three international lawyers from a certain region of the world saying this is what international law is. This is international lawyers from all across the world coming together and agreeing that these are rules of international law. And I think that's quite powerful to be able to get that degree of agreement, not just diverse in terms of being geographically diverse, but also diverse in terms of the backgrounds of people. I mean, from academia, from government, from industry, people who've served on international tribunals.
And also intergenerational.
And also, Telita's reminding me, also intergenerational. I think she's looking at the two of us when she says also intergenerational. Old people like me and younger people like her, I think is what she means by that. So I think that's the value.
So Tomo, if I can put you on the spot, you are someone whose job it is to give legal advice to your own government. Are you now more inclined than you were before to say that certain kinds of activities, when done by a state actor, are not just improper or unwise, but actually illegal? And how do you advise your own government, the government of Japan, on whether it has fulfilled its due diligence obligations when some kind of malicious cyber event occurs?
Thank you for the question. The positive obligation like due diligence obligation appear a little bit scary for the government international lawyers because it sounds too ambiguous and it can be interpreted very widely. So from my point of view, it is important to focus on the what is the core content of the due diligence. There's a anxiety among UN members, I may say, about this due diligence or positive obligation. So we should think about what is constitutes the core of this obligation and how can we do that. I think first we should look at the GGE report. Undersecretary General mentioned the latest GGE report successfully adopted this year. And there are useful paragraphs in this GGE report referring to the very basic things states should do in faced with the cyber activities, including the notification and acknowledgement of the notification. These are very basic things, but as a starting point, we should look at these basic cooperation measures. In addition, as a government of Japan, we submitted a position paper, basic position to GGE, and tried to elaborate on the content of the due diligence obligation. So if you have a time, please look at our position paper. In that position paper, we emphasized the elements of capacity to influence the perpetrators of cyber attack, and also the seriousness of the threat posed by cyber activities. And I think obligation of due diligence depends on these two elements. For example, if state is supporting some person or group of persons, and that group of persons or person engage in the malicious activities harming the critical infrastructure of other states, I think that state, when notified, should do something. If that state doesn't do anything at all, that will be violating the obligation of due diligence. But it depends on the capacity and the seriousness of the threat. In this way, I think we can focus on the core of the obligation. And now we have a good GG report, and we should focus on the implementation of the content of the report. And in doing this international cooperation, we can find out further content of this due diligence obligation. Thank you.
So Toma, if I can just simplify what I think you're saying, you're essentially saying that a state has no reason to feel anxiety about this obligation if it is a responsible member of the open-ended working group, if it's monitoring, if it's participating in the development of the norms, if it's observing the action of actors on its own territory, and if it's trying to take steps to behave responsibly, it's meeting its obligations. But that if it does nothing, then it's violating the principle of first do no harm. Is that a fair summary of what you said?
Yeah. I think states are not required to do something not possible for them. So they can fulfill this obligation within their existing capability. Of course, and notification and acknowledgement is possible for any state. The effectiveness of the countermeasure or the measures against these cyber attacks depend on the capacity. So I think states should fulfill this obligation within their capacity.
And Talita, you're from Brazil. You recently gave a presentation of this kind to the Organization of American States, along with our colleague Duncan Hollis. What was the reaction of those in the OAS to this concept?
Well, I think that states were very keen to learn. And I think that the whole sort of like legal capacity building exercise it can be seen as a due diligence exercise, right? The whole attempt at, raising awareness about what due diligence is in itself a due diligence measure. And in that sense, we got a very positive reaction from member states. Member states were keen to learn more, were keen to ask questions, and were keen to issue position papers on due diligence and other issues, provided that, of course, they had the legal capacity to assess those issues from their perspective. So there is eagerness, there is appetite for due diligence, and in different shapes, in different types. And as I said earlier, due diligence, the main advantage of this principle or this rule is that it's flexible. And as Tomo said, it depends on a state's capacity to act. And so it gives states a wide margin of discretion in terms of measures to fulfill with their various diligence obligations. And so in that sense, what we could notice based on our session with the Organization of American States is that states are keen to learn more about this and to learn more about how they can comply with their due diligence and other types of international obligations that they have in cyberspace.
And you didn't hear any of them say, we just can't do this. It's beyond our capacity.
Not at all, not at all. Not at all, because it was reiterated that states are not required to do the impossible. They need to do what they're capable of. And so I think that reassured states in terms of what was expected from them. No state said, well, actually, no, we don't want this, we cannot do this. I think on the contrary, states, and Duncan can talk a little bit more about this, states were quite open to the ideas that we were discussing.
Yeah, this leaves open for something we can discuss at the end, which is what kind of resource can this initiative provide to states? We have the participation of ICTs with capacities and ability to identify and make attributions, and it may well be that that's something that supports the activities of states in deciding whether international law violations have occurred or not. But with that, why don't we move to put the 5 particular statements under focus. We will move off of the virtual presentation and to our colleagues who are in the room. The first is Professor Duncan Hollis of Temple Law School, who's a co-convener of the process, and Svetlana Van Bentham, who's a research officer for ELAC. Given that this is a presentation which is being co-sponsored by Microsoft, we of course are using PowerPoint. we didn't want you to feel that you hadn't gotten PowerPoint, because if it didn't have PowerPoint, and it hasn't really happened. So Duncan, over to you.
My voice of appreciation, of course, to the government of Japan and to Microsoft for co-sponsoring this. If I can summarize really briefly, I think I don't know if Dapo and I and Harold and Talia and Svetlana, Antonio and others, when we put this together, we were just kind of angry about people hacking hospitals at the beginning of the pandemic and thought, what can we as international lawyers do about it? But as a result, I think we ended up kind of consciously or not, working our way into this kind of inductive process, taking the problem and looking at it from an international law lens, unlike some other processes that have been very deductive, starting with broad principles and narrowing down. And I think we've really been consensus-based. So instead of majority and minority views, we try to figure out what's the consensus we can achieve. And even if we can't achieve consensus on everything, we've actually had some meetings that have not produced a statement and the like. We're still trying to have some forward progress. And I think the other aspects of it, Dapo and Talita eloquently elaborated, is the global nature of this, having participants and signatories from all 6 inhabited continents, having multi-stakeholders, bringing in technical experts to kind of lay out the landscape before we international lawyers were then let at the problem. So I think that's kind of been the process, and it's one where we've been happy to kind of flip the script and have governments and representatives of international organizations observing the lawyers amongst us debating and discussing these topics. And it's a process that we hope to kind of continue to move forward. But what I thought we'd talk a little bit about the product. All of you have a summary of the process in front of you and some of the statements. All of them, I think, have 2 kind of fundamental premises. First, as I kind of alluded, is, and we'll try and make the slides available. They're a little small, so apologies to those you in the back. But this idea that we wanted to work off problems, and the first one we encountered was the beginning of these hacks on the healthcare system. I mean, they obviously occurred pre-COVID, but they were so dramatic in the midst of this. And that rolled into vaccine research and rolled into foreign election interference as we were looking at these issues. And as has been said several times, for us, a fair bit of it was this not just building off, but really trying to take up the invitation that one sees in the GGE report and the Open-Ended Working Group report, that we now have unanimity that international law applies. And as has been said, dozens, if not hundreds of times in international fora, we still don't know how it applies. And this is our contribution. You can agree with it or not agree with it. We were happy to see in all 5 statements, more than 100 international lawyers from all disciplines and backgrounds have signed on. I mean, that's not the whole community, but we like to think at least one that bears attention, as it were. And those two premises kind of are infused throughout all 5 statements. And in terms of our kind of focus, we began thinking about what are the objects and areas of protection. As I said, we started with healthcare and vaccine research in particular, and then we thought about the election context, particularly initially from a foreign election interference angle. And one of the things we tried to do then was to, where necessary or possible, elaborate what we understood the thing in need of protection was. So one of the things we hope the process can help with is, offering, for example, maybe a little more elaborate definition of what an electoral process is in terms of balloting, verifying, and informing, and the different aspects that go into an electoral process that then warrants protection under international law. We also, in our last 2 statements, switched from areas or objects of protection to particular means and methods that we thought are potentially quite problematic under the existing law. And the first was information operations and activities. And in this one is a difficult one because it is avowedly cognitive in its goal, right? It is trying to change not physical outcomes, but change or confirm biases or elaborate biases or sow chaos through disinformation and misinformation. And so we tried to try and capture, we even kind of ended up saying information operation and activities, because we thought that just calling it an operation might in some ways be too limiting to the scope of what international law does in this space. And we also, I think, looked most recently at ransomware and the global problem that ransomware has been causing at almost every level, from my kids' school to hospitals, to municipalities, to private industry, and the like. And what you see if you look at all the 5 statements, I know in the earlier dialogue there was a lot of talk about the positive obligations, but we also thought it was pretty important to talk about what was off limits. Beginning with the idea that international law prohibits cyber operations by states that have serious adverse consequences for essential medical services. That certainly in wartime, as our statement elaborates, these are off limits. But we wanted to make it clear that in peacetime too, you don't get to hack hospitals and the like. Before handing it over to Svetlina, I'll say one of the things that was really interesting for us now a year ago last summer was in our second meeting, we brought in the Chief Information Security Officer for one of the major vaccine processes that ended up resulting in the AstraZeneca vaccine. And that was quite informative, because I think for many of us in international law, we're used to thinking espionage is extra legal or is specifically permitted by international law. But in the vaccine research context, we were kind of informed that clinical trials, if they are corrupted in any way, that is, even if they're just surveilled, the risks the trial being failed. And so that one of the things we wanted in this statement to do was to communicate to states something they may not have understood, was that in this particular context, the sorts of things that they have thought were de rigueur and allowed for generations had to be rethought, lest at a particular time when we were all desperate to get vaccines to market, you end up slowing that process down at a very real cost of human lives. And so when you look across the statements, we have tried to lay out things that are off limits to states. And you'll note we haven't actually always said what the exact rule that makes it off limit is, because we found for consensus purposes that we could get international lawyers to agree that something was prohibited without necessarily getting agreement on why it was prohibited. Everybody would agree to the statement, but they'd each have a different reason. And so one of the things the Oxford statements try to do is take advantage of the consensus around the end result, what's off limits, even if we couldn't achieve consensus on why that's so. But maybe I'll hand it over to Svetlina to kind of walk you through a little bit more of these products.
First of all, let me say what a pleasure it is to have so many of you with us today. I'm going to take the floor with 2 additional features of the Oxford statements that we see across all of the 5. And the first one has to do with the typology of different obligations that we see in the statements. And the second has to do with the extensive substantive coverage of those statements. So just taking off of the comments that were made by Undersecretary General Nakamitsu, she mentioned that the question of how international law applies to ICTs is both critically important and still controversial. So the Oxford process is really trying to clarify and to unpack the ways in which international law applies. And under international law, we can see that there are two types of obligations, broadly speaking. We can talk about obligations to refrain from certain type of conduct, that is negative obligations. And we can also think about obligations that require the taking of certain steps, the taking of certain measures, otherwise known as positive obligations. And the Oxford process looks at both types of obligations. We're going to run through a couple of examples. And here you can see excerpts from the Oxford statements, first of the negative types of obligations. This first one is taken from the Oxford process on electoral interference through digital means. And what we can see is precisely this statement that was made by Duncan before, that there was agreement that certain types of operations in electoral processes that cause adverse consequences are prohibited. So as Duncan mentioned, our participants didn't necessarily agree on the specific rule that would lead us to this outcome. For some of them, this would be the principle of non-intervention. For others, it would be a self-standing rule of sovereignty. For yet another group, it may be human rights obligations. But what was really important was that there was agreement across a significant number of international legal experts that those types of operations causing adverse consequences in electoral processes are off limits. So then you can see that what we have done is to further clarify, to provide a little bit more granularity to this statement by giving different examples of prohibited conduct. You can see that we look at interference with balloting and with verifying results, with the different ways of influencing the ways in which people participate, individuals participate in electoral processes, and also interferences with human rights. Now, in some of our later statements, we saw enough consensus in the virtual room across our participants to be able to give explicit rules of international law that apply in those domains. The second example is from our statement on ransomware operations, where you can see an explicit mentioning of principles of sovereignty and non-intervention. You can see a reference to the Charter of the United Nations. You can see the reference to the prohibition of the threat and use of force. So this was significant because you can also see a specific type of evolution across statements in the way in which we mention specific types of obligations. So I hope that this is giving you a sense of the type of structure of those negative obligations that we have looked at. And now let's turn to the positive ones. And I think that moving towards the positive ones, we're also moving towards one of the areas in which the Oxford process has had some of the most significant contributions. Because effectively what these positive obligations are showing is that there is agreement that there are a number of obligations under international law that require the taking of certain steps to protect the interests of other states and to protect the interests of individuals from specific types of harms through prevention, mitigation, halting, and redress. So this was really important across all of our statements, and some of the examples that you can see here are first from our statement on vaccine research and the protection of vaccine research. You can see reference to the emanation of certain operations from the territory of a state, the requirement to take measures in such circumstances. You can also see a reference to human rights, both civil and political, but also social, economic, and cultural rights. And then there is something interesting to note. Talita spoke about the evolution of talking about protective obligations. And we can see in further statements that there are three features that seem to permeate these obligations. One of them is that, of course, their very mention shows consensus on the applicability, but also on the specification of these obligations. The second one, and to Tomo's point on implementation, we have sought to provide practical measures through which these obligations can be discharged. And then finally, when we see that there is a potential for an interference through such measures with human rights, there is an explicit note that there should be compliance with the criteria for lawful interference. And the reason for this is that we may very often find ourselves in situations of thinking about monitoring, but also concerns over privacy or suppressing certain types of harmful speech, but also the right to freedom of expression. So this is the reason why you can see in later statements a way more granular clarification of these standards. And it is really interesting and important to emphasize that meaningful protection can only be ensured by having a holistic idea of the different international legal rules that apply in this space, both positive and negative in character. It's not just about what you should abstain from doing, it is just as much about what you should do to halt, to redress, to prevent, to mitigate. And there should also be an understanding that these obligations protect different types of interests. They may protect the interests of other states, but they may also protect the interests of individuals. And a significant part of the Oxford process has been looking precisely at questions of human rights law. So in a sense, these Oxford statements are a reminder that when states are thinking about drafting their national legislation, their cybersecurity strategies, think about mitigation measures, human rights consideration should be front and center. And with this, very briefly, I'll turn to the final slide and the final feature of the statements, which is about extensive substantive coverage. One aspect of this is that we look both at situations of armed conflict and peacetime. This is because we seek to provide a full picture of the applicable legal obligations. And then the second feature is that we're looking at obligations not just of states, but also of other actors that they directly bound under international law. So across statements, you can see references to the obligations of individuals under international criminal law, but also when we speak about international humanitarian law, these are obligations that apply to parties to conflict. So in non-international conflict, this would be both states and non-state actors. Thank you very much once again for being with us. These are the features, and with this, we conclude our session on the substantive point. Thank you.
Thank you. And to open our question and answer, we wanted to give the two Undersecretary Generals, if they wanted a chance to comment, and we'll start with Miguel.
Yeah, a very general comment, and with my apologies because I will have to leave after. I wanted to share some of the value that I found in this process. I mean, for me personally in the UN, just having sometimes time to think is precious. So it's good to have outside the intergovernmental process a group of experts that is thinking and helping, you know, our own thinking about this. But I think this is very helpful for states. These topics, and it's one of the areas that the lawyers cannot work alone, even if we lawyers think we can do everything alone. This is not an area where we can work alone. But I have the feeling that in member states, a lot of them do not have this expertise to discuss these matters. And the expertise that might be there is not necessarily in the foreign affairs departments. You may find some in defense, some in private sector. So this exercise is actually very helpful for states to enable them to participate in these future discussions with a better basis. And it's good to have this thinking outside the intergovernmental process. I mean, I have to clarify, I did not sign any of the statements because as a high official of the UN, I thought it's more compatible with my status. But the high degree of consensus that they reflect, it's in itself a value. I mean, I was just commenting with Harold, I find it surprising in a positive way that the statement that had the most signatories is about foreign electoral interference. That's actually very interesting. Thank you so much.
Thank you, Miguel. Undersecretary.
Well, thank you. As Miguel says, indeed, sometimes we find it really a luxury, trying to cope with all sorts of daily demands. It's a luxury for us to think very much, in depth and articulating the approach. One thing that I find especially useful is your approach of articulating points of consensus. We have a tendency in the UN, especially in a negotiation, very difficult, divisive environment. What we see immediately is the point of contention, disagreements. But I hope that this would also further develop, not just looking at articulating the points of consensus. And it doesn't really have to be low-hanging fruits, as the document actually pointed out. If you can also find out and further develop a methodology of widening the points of consensus, what actually unites what might be the common grounds potentially for different positions, what kind of arguments that you can use to bring these different positions, I think it would be hugely useful for the actual people, like Michelle and others sitting here who will be looking at those issues in the intergovernmental process. Thank you.
Thank you. And let me, we should give a round of applause to our two guests and give them a chance to go back to their. Thank you. We do have some time for questions, particularly for those in the room. You all have microphones, and the question is, do you have any comments or questions? And also, we may be having some questions online. Are there any questions? Yes. Let me start with you, and then Chris, did you have your hand up? Yes.
Well, my name is Tadeusz Chomicki. I'm head of the Polish delegation to the Openended working group, and I'm ambassador for cyber and tech affairs back home at the Minister of Foreign Affairs. I think this is a great thing, what you're doing here, and I wanted to thank, of course, the organizers, sponsors, co-sponsors, Undersecretary Generals for the presence, and everyone who is making this process available. It was very rightly pointed by our host that many states do not have these capacities to do the analysis. Even countries which have the capacities, they are not used to have this analysis done in that way, because I hopefully have my colleague from the Treaty Legal Department of the Minister of Foreign Affairs listening to us. He's very good, but he just started to do the cyber things, right? Because we did not have the tradition. We didn't have a separate unit doing the legal cyber issues so far. So the expertise was coming in bits and pieces from different places. So this is, for sure, this is very welcome. And the biggest question from person who is rushing soon back to the meeting room across the street is how we can really make use of what you're doing in the process. That was also mentioned. The point that the Secretary made, that how we can find for the points that could actually help us in the consensual position when we have the differences of views is very important, including the one that we're discussing now, which is how to expand the basis for the non-state actors participating in the process in such a way that we can make use of substantial achievements that they have. The argument I was trying to use in the discussion is that back home, so the national level governments, we actually cannot imagine how we can make now the regulations on cyber, how we can make the resources available on cyber, how we can develop tools on cyber without talking to multi-stakeholders, because the expertise is not in the hands of the governments. The decision-making process is in the hands of the governments. This is the administration's decision, after all, how we use them, but we're lacking this. And especially the legal approach, which is strictly not strictly legal, but is cross-sectorial legal analysis, is very welcomed, because this is also what we're missing, right? We have lawyers specialized in specific aspects of these things, but cyber realm is a new thing in general, right? It's not new, but the overwhelming power of cyber presence these days is is a new thing, and a lot of entities, even in relatively well-developed countries with resources, relative available resources, we're still missing this experience. So and this kind of analysis. So go on. My heart is with you, and how to. We shall all think together on both sides how we can make the better use of what you're doing there, which is very interesting, and widening our horizons. How we can make a applicability of that to what we're doing in the UN building now. Thank you.
Thank you, my old colleague Chris Painter.
Thank you, and I found this whole exercise, and I've said this to Duncan before, incredibly useful, because tying it to individual fact situations, I think, brings it home for policymakers a lot more, particularly the ransomware one now. And the due diligence issue has been debated with respect to ransomware a lot. And I think this piece is very helpful. I'd say, however, that you need to do a better job of promoting this, in the sense that a lot of the policymakers don't even know that the work you're doing exists, particularly in this area. And I think ransomware is sort of the flavor of the day right now, and it's one where, an important flavor of the day, but one where you can do more promotion. And you know, part of that could be in capacity building, legal capacity building. Certainly the group I represent, the Global Forum on Cyber Expertise, you know, we can figure out how we can work together on that. It was also interesting you talked about the fact that, you know, no country should be asked to do something impossible, and that's true. And there are countries who don't have the capability to respond, and capacity building helps that. But there are other countries that do have the capability to respond. And I guess the question is, and when you were having your discussions, and I didn't see it in the actual paper, you know, what constitutes not doing due diligence? In other words, if a country simply says, "Oh, they're those crazy criminals, we can't do anything about them," you know, I wish we could, and they clearly have the capability, how do you deal with that situation? Which I know is more of an implementation question than a straight legal question.
Well, I think we're just about out of time. What Chris has flagged is our the eternal dilemma, which I learned when I first went into the government, which is that those influence and those with influence have to try to bring it together. Chris mentioned the goal of trying to promote more what we're doing. We will try to get online. As a way of looking forward, I think we've gotten a wonderful summary here of what we think are the distinctive features of the Oxford process, that we focus on consensus and context, real problems, a regulatory focus. It's inclusive of both states and non-states. It's a focus on no-fly zones, illegal means and methods, trying to decide which things are off limits. And as time goes on, to try to refine a typology of obligations which might well work. I think as time will go on, we will do more clarification of the sources of these obligations in the Charter, in rules of humanitarian law, human rights law, international criminal law. I think we are now at the end of what we could call Oxford Process 1.0, and we're really moving to 2.0. We're emphasizing a set of principles that you could call trans-substantive. For example, the due diligence principle cuts across a number of different areas, as we're saying. It's transnational in the sense that it involves protection of both individuals and states. And it's trans-situational in that it covers all the various uses of cyber in our daily lives. And cyber is becoming totally pervasive in everything we do. For those of you who are now have joined us in this discussion, we welcome you. We can say that the next steps will be that we will publish the documents that you have in a compendium. We know that the Undersecretary General had herself thought of the idea of developing a compendium of state practice in this area, and we think that that's critically important for us to do and to have as a resource. The Oxford process will convene future meetings, probably starting this spring. Our focus, we think, will be on legal capacity building, both regionally and nationally, and how this multi-stakeholder initiative can give support and resources to nations who are trying to develop their capacities and to make sure they're fulfilling their obligations, positive and negative. And finally, we're open to your own thoughts as the Open-Ended Working Group continues its work and the GGE continues its work. It may well be that there's a possibility for division of labor or pulling these different strands together. There are many areas of law where many discussions took place before they were able to get to comprehensive international lawmaking. This may well be one of them. But I think there's no doubt that this is the issue of our time. It is the means of addressing every issue of our time. We face a number of existential threats, and all of these will be affected by whether we're able to use this tool of cyber communications safely, effectively, in a way that it can be trusted for the development of a humane process of globalization. So we thank you all for coming. We thank those of you who are joining us online. We're sorry we weren't able to get to all of your questions, but we'd love to continue to engage with all of you. We welcome all of your email addresses, and we will be contacting you about the future sessions, which we hope will continue to incorporate important issues of both law and policy. So thank you very much, and thank you for coming today.